My narrative today is going to be straightforward initially. It's going to be linear, and then towards the end, I'm going to jab you a little bit about the First Amendment and try and make it more interactive and comparative. So I'm going to start off with a little bit of scene setting, then plot development, plot thickening, a couple of cliffhangers, commercial break, and then I'll crowdsource the rest. Okay, but I think the initial scene setting is important in order to give you a sense of the legal contextualization of regulation of hate speech in Europe, such as it is. And I'm going to begin with the centerpiece of human rights protection in Europe, namely the European Convention on Human Rights. Now, I would argue that there is a broad congruence between Article 10 of that convention, which deals with freedom of expression, and the First Amendment to the US Constitution. One of the leading expert on Article 10 of the European Convention, Professor Geert Voorhoff, has consistently referred to it as the European First Amendment. I'm very curious to see if they tease out the extent of that congruence with you at the end of the proceedings today. Because very often it's a case of Article 10 and the First Amendment being fellow travelers on their journey into the realms of freedom of expression. The key difference, however, is that at a certain point, the First Amendment tends to travel that extra mile. But you'll see in the jurisprudence of US Supreme Court and the European Court of Human Rights, lots of shared concepts and even terminology like chilling effect and good veto. So there is that broad congruence, I would submit. Let's take a little look at the text of Article 10. Everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. So far, so good. Big, bold, sweeping statement of principle. But then the drafters had a panicky moment. They suddenly they got a little bit dizzy when they realized the heights that they had scaled. So they immediately started scrambling back downwards to control the situation again. And in the first paragraph, which is supposed to be just the enunciation of the principle, they immediately tried to claw back what they've just announced. This article shall not prevent states from acquiring the licensing of broadcasting, television, or cinema enterprises. Then it goes on to paragraph 2, which was supposed to be the itemization of permissible limitations of the right to freedom of expression. And as you can see there, that is very detailed. They enumerate a number of grounds on which it could be permissible to limit the right to freedom of expression. Look at this. In the interest of national security, territorial integrity, public safety, prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary. Now that appears to be, I see some heads shaking already. That's good for the discussion later. But you see here, even if you look at the reference to the rights of others, that's quite open-ended because, and it indicates that it's not limited to the, by way of a backdoor entrance, it's not limited to the grounds enumerated here. You must see the European Convention as very much a product of its times, the aftermath of the Second World War, and that's why there was an apprehension about the power of mass media, and that's why the urge was felt to restrict the freedom of mass media, and including cinema, because of the devastating effect that cinema propaganda was put to in the Second World War. And look here, this is also interesting. The exercise of these freedoms carries with it duties and responsibilities. Again, very much a product of the zeitgeist and a fear of abuse of the right to freedom of expression. You'll see similar language in Article 19 of the International Covenant on Civil and Political Rights for similar reasons. It was to prevent a repetition of the abuse of freedom of expression during the Second World War. So perhaps because of those provisions, people like Fred Schauer have described Article 10 of the European Convention as being more communitarian in its outlook than perhaps the First Amendment. And I think that's an accurate characterization. Moving on then to the next slide for some visual diversion. It's always great to be Irish, but particularly when you're explaining how Article 10 works. Stemming from one textual provision, you have three distinct components to the right. The freedom to hold opinions, receive and impart ideas and information of all kinds. Okay, you'll note there that there's no right to seek information, but that has actually been read into the right through subsequent case law by the court. A second reason why you can hijack the national emblem and for explanatory purposes is that it gives a good indication of the three parties or sets of parties that are explicitly implicated in the exercise of the right. There's the speaker, the listener, and third parties or society. Remember that reference to the rights of others. That's central and very important in how Article 10 is interpreted. Okay, so continuing my point about there being congruence between the First Amendment and Article 10, we've got, this was all very much opened up by a seminal pronouncement by the court in the Handyside case. Let's take a little look at it. It says, freedom of expression is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb the state or any sector of the population. Such are the demands of that pluralism, tolerance, and broad-mindedness without which there is no democratic society. That resonates very strongly with the famous pronouncement in US case law that public debate should be uninhibited, robust, and wide open. The question, however, is to what extent that comparison stands up. How far does it stretch in practice? And this is crucial for how the European Court of Human Rights deals with hate speech. Because on paper, that sets out a very wide zone for vigorous public debate, for confrontation, for the differences of opinion that are part and parcel of democratic exchange. Very, very important because it opens things up considerably and it reduces to an extent the effect of the extensive limitations set out in Article 10.2. But again, how far does it stretch? Is there, for instance, and religion is always a flashpoint when it comes to sensitivities and hate speech, is there, for instance, a right not to be offended on the basis of religious beliefs? Remember that in Handyside, it said that those beliefs that offend, shock, or disturb should be part and parcel of freedom of expression. But is that always the case? And again, it gets a bit tricky with religion. And the court has come up, I'll spare you all the ins and outs of the case law, but the court has essentially come up with a very laboured approach to questions of religion. They talk, referring back to the duties and responsibilities that govern the exercise of the right, they say that there is an obligation to avoid, as far as possible, expressions that are gratuitously offensive to others and thus an infringement of their rights, and which therefore do not contribute to any form of public debate capable of furthering progress in human affairs. So you've got a number, and again I see more head shaking, which is again very promising for later, but you see a number of problematic variables here. What is gratuitously offensive, and again this requirement that it would contribute to human affairs in order to pass muster. Problematic and laboured and perhaps a bit contrived. We can get back to it later. In the meantime, though, and this is important for setting out the limits of the Handyside principle, there's what is sometimes referred to as Karl Popper's paradox of tolerance. And according to that paradox, in order to be tolerant, you have to guard against the excesses of tolerance. Or to quote Umberto Eco, in order to be tolerant, you have to define the limits of the intolerable. And this is essentially the approach taken by the European Court of Human Rights. This, you can't see it very well, and it's in Dutch, but this was, nevertheless, it's an interesting example. Here you've got a poster on the main street in Amsterdam, which says, Amsterdam eens en altijd tolerant, weg met wilders. Or in translation, Amsterdam once and forever tolerant, away with wilders. Wilders is a far-right Dutch politician who wouldn't be renowned for his affections for immigrants, and in particular Muslim immigrants, to put it mildly. But this is how the European Court of Human Rights has tried to square the circle, by referring to Article 17, Prohibition of Abuse of Rights. Basically, this is a safety valve built into the convention to prevent people from abusing or misusing the rights guaranteed in the convention to go against the letter or spirit of the convention. This has the consequence that neo-Nazis or racists cannot invoke the provisions of the convention in order to assert free expression rights. And again, sparing you the ins and outs of case law, these are basically the categories that are denied protection under Article 10 by virtue of the relevance of Article 17. Racism, Nazism, neo-Nazism, anti-Semitism, Holocaust denial. Should specify that that is not just outright denial of the Holocaust, but also the disputing, minimization, or condoning of the Holocaust. And the thinking behind that provision by the court is that it is a violation of the dignity of the victims and survivors of the Holocaust, and that it is a contemporary vehicle for anti-Semitism and racism. And then hate speech, in inverted commas or scare quotes. I'll get back to that in a moment. The most recent addition to the list is homophobia. And that was just within the last year or two that the court recognized explicitly that hate speech could be that homophobic expressions could be categorized as hate speech. There's a very clear reason for that late arrival of homophobia in this list. And again, that has to do with a very particular period in history and political priorities that were developed during that period. This is the closest we have to a definition of hate speech. It was developed by the Committee of Ministers of the Council of Europe, which is, if you like, the executive organ of the Council of Europe, an intergovernmental organization of 47 member states. And it says that the term hate speech shall be understood as covering all forms of expression which spread, incite, promote, or justify racial hatred, xenophobia, anti-Semitism, or other forms of hatred based on intolerance, including intolerance expressed by aggressive nationalism and ethnocentrism, discrimination and hostility against minorities, migrants, and people of immigrant origin. So you see there a clear line that corresponds to the initial list of forms of hate speech. And as I say, look at the period in which that was adopted, 1997. That was a clear response to the unfolding situation in Central and Eastern Europe and the resurgence of extreme nationalism and xenophobia in a large number of Central and Eastern European countries. So that explains the bias for xenophobia and racist forms of hate speech. As I say, homophobia has now been recognized by the court in a different political context, and I think it's very probable that this growth trajectory of hate speech will extend further in the fullness of time to include, for example, your status of having disabilities, or your status as an elderly person, or any of the conventionally recognized grounds for discrimination, when that's a key aspect to your identity. So that's one of the new frontiers of hate speech, a new conceptual frontiers, if you like, that I alluded to in the title of my presentation. Okay, this definition is not legally binding. As I say, it was elaborated by the Committee of Ministers of the Council of Europe, but it's the closest we've got to a legally binding definition. The European Court of Human Rights first introduced the term hate speech on the 8th of July 1999. I must check the weather in Strasbourg on that particular day. It was a momentous occasion for hate speech in Europe, but there was no explanation by the court as to why they were introducing the concept all of a sudden. There was no explanation as to what its relationship would be with previous case law on relevant matters, nor was there any attempt to define the notion. Now, in its subsequent application of the term hate speech, the court sometimes puts it within scare quotes. And that for me is an indication of a certain unease with the topic, that they haven't fully integrated it into their thinking. And in the absence of a fully theorized approach to hate speech, I think this is problematic because it's not clear what it exactly covers. On the one hand, it could include extremely negative forms of stereotyping. That's maybe controversial, but not to be ruled out. And on the other hand, it would typically and certainly include incitement to hatred or the more egregious forms of expression. But it's very important to have more clarity on that because obviously you want to calibrate your regulatory responses to hate speech to address the harms caused by the particular types of speech. And I should add that the regulatory approaches wouldn't necessarily have to be criminalization or legislative. It could also involve educative, informative measures and other initiatives that would stimulate intergroup interaction. Conscious of time, I'm going to speed up a little bit. The cliffhangers I promised were, that there is, it's now one of the big challenges and one of the new frontiers of hate speech regulation will be to engage with forms of media that are unfamiliar to us. This is unfamiliar for the wrong reason. It's an ancient toaster. Well, ancient, it's from the 1900s, and it's triggered by a famous quote by Mark Fowler, one of the former FCC chairpersons. Television is just another appliance. It's a toaster with pictures. Okay, but needless to say, the media have moved on significantly, and we're dealing now with an astonishing array of different players in the communications landscape, all of which have different objectives, functionalities, and levels of impact. And this is the cliffhanger that I want to set up for the interactive part of the discussion. It's also the commercial break that I announced. It's a commercial for my own research while I'm here. I'm particularly keen to look into the regulatory and policy implications of this increasingly diversified and increasingly noisy communications environment, because all these international and European treaties were drafted in a context in which the only way that individuals could communicate to the masses was through centralized, mediatized points of communication, namely traditional media. That has exploded, and so much so that very often the presence of these new actors is described as disruptive, which is a compliment as well as a disparagement, I guess. So these are the big questions that I want to engage with while I'm here, and I'm hoping to get to glean lots of comparative insights from the way the US has dealt with these issues, both in terms of law policy, also case law, and in practice. Okay. Then I think this image designed by my niece captures it all very, very well. You see the print medium turned on its head. You see the old familiar television sets floating up amongst the clouds where so much information and communication is these days. I think it encapsulates brilliantly the contradictions involved here. And if there was ever any suggestion that the individual players in this reconfigured communications landscape were insignificant, that they were perhaps the poor and puny anonymities referred to in earlier US jurisprudence, I think that has to be countered because of the speed and instantaneity and international character of communications these days. Also, you've got the big, powerful actors such as Google and other search engines and the controllers of the owners of Facebook, Twitter, etc. And these are the intermediaries that Ellen referred to in her introduction. Okay, these are some of the issues, they were already in my paper, these are some of the issues that, specific issues that are becoming increasingly relevant for hate speech in this reconfigured communications landscape. Of course, you've got bigger overarching issues like questions of jurisdiction, how to deal with the idea that information or expression here or information expression there is simultaneously information and expression everywhere. and the recent controversy surrounding the movie The Innocence of Muslims is perhaps a good illustration of that in practice. So you've got the big jurisdictional questions. You've got the big liability questions. How do you apportion liability for hate speech? Does that go to the individual originators of the expression? Should it be in some way ascribed to the intermediaries? At what point does it kick in that very, very networked environment? And then you've also got the impact of all these new technologies on the victims of hate speech themselves. It's interesting to see the engagement of critical race theory with these new instrumentalities of internet-based technology. For example, the fact that racist insults directed at an individual or a group would be retained in cache form on the internet after its deletion, on the original website, that could have, and I quote, a compounding and incessant impact on the emotional distress caused to the victim. Again, an interesting line of inquiry. Whatever happens in terms of future regulatory approaches, in Europe at least, the relevant actors have to be very careful that they don't drift too much from the gravitational pull of Article 10 of the European Convention on Human Rights. Because if you've got policy-making organs within the Council of Europe who are taking their own initiatives as regards developing policy to engage with hate speech in the internet-dominated environment, they have to be very sensitive to the legal underpinnings of any approach that they would take. The role played by such actors is crucial because the court has a staggering backlog of cases which is a partial explanation as to why it hasn't fully engaged with the impact of the internet for freedom of expression. Another reason why it hasn't engaged with the full extent of the internet's impact on freedom of expression is a certain conservatism and a lack of knowledge or understanding as to how it actually works. You've got a very generally a court of judges who wouldn't necessarily have the benefit of keen insights into these new technologies. And they're struggling. They're really struggling to keep up with the new issues that are upon them. So this is, there's a lot of dot joining to be done by the court and by policymakers to connect the legal issues and their principles to statistical evidence, empirical research, and policy-making initiatives, and come up with something that is legally sound, forward-looking, and informed by realities on the ground. So it's an intricate dot joining exercise, and you have to be very careful, because if the end picture looks like Santa Claus, it might be difficult to assert its credibility amongst the people that it is most directly going to affect. So that's my part of the presentation. Now I'd be delighted to crowdsource the rest and ask you about the congruence between the two instruments that I've mentioned, and also I'd be very curious to hear about your experience of US approaches to these issues that I've outlined.